I want this video private. This okay. This private. It should say private. Wow. These guys must be working like triple time. Have comments over here? All right. We are live, Christine. So here, hang on. What's going on there? Hang on, Christine. That's odd. Christine's on the video, but yet you're not. Hang on. Should be on the YouTube video. And you're still not on the YouTube video. What the heck? How does that even happen? What? Man. Oh, that's a badass hacker. You're pretty good, dude. Yeah, you need to come and work on our team, man. Who's paying you? How much? We can possibly double it. We're taking donations. All right. Let's see. Christine has to type everything, so I'm going to read what Christine is typing. She's going to talk, I'm going to type, or she's going to type, I'm going to talk, which is probably more beneficial. My hackers are always trying to shut me up. Yes, I get it. She's alleging the alphabet agencies. I'm not going to be specific about which one she's talking about. Yeah, they can't see you. Hang on. I'm gonna take a hang on, put that on, put that back up, put that back up, put it back up. There you go. Let me screenshot that guy. Whoops, do it again. Oops, there we go. Got it. All right. This is her hacker. That's her hacker right there. This guy. It's the only way I can show you this stuff. Y'all see this? Y'all can see up here, right? Or maybe? Hang on. What do I got here? Oh, you can't see. Okay. So I'm gonna have to go. Wow. He has about a 10-second delay through with this signal. Yeah, he's pretty good. I've never experienced a hacker like this, so this is all new to me as well. I'm glad we're getting it in real time so you guys can witness it. Um, Let me open my screenshot so we can get a picture of our fine friend here who's disrupting our interview that we've been trying to get scheduled for several weeks now. Screenshots. Here we go. And let me get to the latest one. Ah, here we go. All right, brother, we're going to make you a star. You are now a YouTube star. You ready? And there he is. And he's obviously celebrating the holidays wherever he's at. And carding still alive. All right, let's go on and see what you guys have to say over here in YouTube. What's going on, guys? Oh, thank you. Yes, I clean up very well. Thank you for that. Uh, Christine is being hacked. So I was in the process prior to going live because we hoped that maybe going live on YouTube would fix or remedy her situation to allow her to be able to speak, but that's not happening. So um, I was on number 7 of your 16 facts or proof of claims. So let me address number 7. I will re-upload this video as well, even though we are live, but it is incomplete because you're missing probably the first quarter of it. I do apologize for the technical difficulties, but we know who to blame now. Number 7, Broward County officials, 2022 general election results logged 10%, or I covered that, 10.01%. Ballots cast as blank, which means there were no votes. Number 8, official summary results show 78,106,957 dashes instead of whole numbers within candidate races or ballot types totaling over 29 votes, which violates Florida statute. Number 9, official precinct level results show 75,482,035 dashes instead of whole numbers within candidate races or ballot types totaling over 29 votes, which violates Florida statutes. Number 10, based on the combined summary and precinct level official results during the 2022 general election cycle, there were a total of 153,588,992 violations of Florida statute combined throughout Florida's 67 counties. Number 11 Florida counties took funds from that originated from Mark Zuckerberg and Chinese citizen Priscilla Chan by way of 2 front companies and signed contracts that ultimately relinquished power to Mark Zuckerberg and China, which is treason, fraud, and invalidates the election in those 11 counties because, number 1, the funds were all at least partially derived from an enemy of the state, Priscilla Chan, due to her status as a Chinese citizen and China's active war doctrine claiming to be at war against the United States through the use of unconventional and irregular warfare, including, but not limited to, election interference. Number 2, use some of the illegal funds after the state had outlawed the acceptance of such funds per Florida statute. And number 3, never had the authority to receive funds from a source other than the state of Florida, dispersed by the county to the supervisor of elections duties as described in Florida statute 2 statutes. Number 12, almost done. 35 Florida counties used uncertified clear ballot auditing products which disclose vote totals real time and are connected directly to computers which are connected to Wi-Fi. 49 counties used ES, ES and GS, ES and S equipment during 2020 and 2022 election cycles that were not federally certified due to built-in modem vulnerabilities, and in such could be used at a state level since the state accepted federal election funds, nor could the election be certified due to doubt created by using uncertifiable equipment. Number 14, in Florida counties, 18 Florida counties allowed foreign interference in their 2020 and 2022 election cycles by using foreign-owned Dominion products, which are largely or exclusively made in China. Number 15. You have in parentheses, remove, use as an argument or as an example addressing rampant fraud. Hillsborough County Supervisor of Elections Craig Latimer used dashes instead of whole numbers to represent votes during the 2022 election cycle to hide altered totals in violation of Florida statute. And last but not least, number 16, included but not limited to, all 67 supervisors of elections have joined the Florida Supervisors of Elections Incorporated, which is a lobbying organization acting in violation of the best interests of Florida residents and voters. The Sunshine Act, which most of people will not understand what that means. Basically, a Sunshine Act is a provision that provides term limitations to some law or a committee or something like that with the state. And the IRS's 501c3 mandate. And then number 17, on and on and on. It just goes on. And as you see, I've lost Christine's video. This is what we're going through. So those are 16 of multiple claims that Christine has made. So what actually am I reading here? This is to the United States Supreme Court. Christine Scott is the petitioner versus Ronald DeSantis et al., which means there's more than one respondent or defendant in the original case out of Leon County, Florida. And this is an application to Associate Justice Clarence Thomas seeking review of petition for writ of certiorari under Supreme Court Rule 11 and 12, Federal Rules of Appellate Procedure, Rule 2, and the 11th Circuit Local Rule 2-1, originating out of the Florida Leon Circuit Court. Case still open but appears to be closed, which blocks it from moving forward or being heard. And we're still waiting on Christine. And this is what I have in my hand here. And this is this is 51 pages. This is 51 pages of 982-page instrument submitted to the Supreme Court. And this is the first 51 pages, which is here we go. The emergency application regarding election fraud affecting national security, brought under United States Supreme Court Rules 11 and 22, Federal Rules of Appellate Procedure, FRAP. You'll hear me label it as its acronym, and the 11th Circuit Rule 2-1, which is a 11th Circuit local rule. And I will address it to the Honorable Clarence Thomas, Associate Justice of the Supreme Court of the United States and Circuit Justice for the United States Courts of Appeal for the 11th Circuit. Petitioner, pro se litigant Christine Scott, herein known as Scott, seeks an order pursuant to 28 U.S.C. 2101E, Rules 11 and 22 of the United States Supreme Court, Rule 2 of the United States Court of Appeals, and Rule 2-1 of the 11th Circuit to set aside the 2022 general election and holding it anew. The Leon County Circuit Court, assisted by the clerk, have conspired with the First District Court of Appeals to block the case from moving forward, which is why Scott cannot take the traditional route to arrive at the Supreme Court. This case is based on an election plagued by over 38 statutory violations of fraud by state and county officials, where the election machines were either not certified, certifiable, or both, where the state's official records claim no registered voter from any party voted, and where candidates certified their own races. This misconduct, fraud, and corruption took place in all of Florida's 67 counties. And I'm just giving you the meat and bones of this. The state of Florida and our country is currently under attack by both foreign and domestic entities which seek to destroy her, the state of Florida, on many levels, including but not limited to through abuse of election process, which has been completely overtaken in Florida, amounting to no less than a coup by traitors from within, working within foreign enemies, showing that the case is of such imperative public importance as to justify deviation from normal appellate practice and to require immediate determination in this court. See Title 28 U.S.C. Section 2101E, Rule 11, certiorari to the United States Supreme Court of Appeals before judgment. Now, she also has on here as a footnote to footnote 5, which denotes enclosure D1. J. Lee Marsh added to contest of election for aiding defendants in acts of RICO and treason. Well, there's no allegations of RICO that I've been able to find in here, so I was curious about why that was in there and how it was labeled and whether it's being pursued by Christine or somebody else or in a future potential filing. Scott requests this court implement FRAP Rule 2, suspension of rules, which states, and I quote, on its own or a party's motion, a court of appeals may, to expedite its decision or for other good cause, suspend any provision of these rules in a particular case and order proceedings as it directs. And as it is described in the 11th Circuit Rule 2-1 court action, which states that in lieu of the procedures described in the 11th Circuit rules and internal operating procedures, the court may take such other or different action as it deems appropriate to avoid a successful coup and overthrow of both the Florida and national government. It is imperative that Justice Thomas review this case, which it has been caged in and blocked from being heard or moving to a higher court by Leon County Circuit Court, as well as clerks and Chief Justice of the First District Court of Florida. Well, there's Christine again. So thank you, Mr. Hacker or Miss Hacker. You know, we don't know what you are these days. You could be a miss, a Mrs., a his, a her, it, a thing, a monster. You know, if you're a monster, you're just a human. That's all. Y'all do know that, right? That's what they think of you. These people. The case is open in Leon County Circuit Court. The chief judge went so far as to assign a new judge, but the clerks have refused to show that the case is open on the docket. The case is closed. It looks like the strategies fall until after the 2024 election cycle and then to call the case moot. Scott has a right to fair trial. She has a right to have evidence heard in the case. Her evidence is solid, and if heard, she will win the case, and the people of Florida will rightfully be able to have a new election. Each Floridian has the right to have their vote counted, yet not one was counted, according to Florida's own Division of Election Statistics. That's pretty astonishing. How do you even have a winner if there's no votes? You still can't speak. That's well, you can speak. I just can't hear you. That's bizarre.
Okay,
Oh,
can you hear me?
I heard
No?
something. Come on, man. Speak, bro. Please. Come on, man. Give me 60 minutes. 60 minutes. Come on. Be nice. It's Thanksgiving. Yeah, I know he's over there hard at work. He hasn't looked up yet, has he?
Can they see me?
Wave high. Yeah, it really sucks. Okay, so I've gone over. Yeah, there's such a delay.
He's looking up.
Finally. Hey, bro. Come on, man. Cut her some slack. Cut me some slack. Come on, man. Put you on the Fearless Floyd team. I mean, it's cute, it's adventurous, man, but it gets old and dull quick. That's all I'm saying. I mean, if you're getting paid for it, I get it. But if you're not, you're just having fun, getting some shits and giggles, that's not cool. So sorry, bro. Anyway, so I've gone over all 16 points. I'm going over some of the highlights of this particular filing. I haven't even gone into the mandamus yet. Let me ask you this. You mentioned here in footnote 5, right here, where you're discussing enclosure D1, where J. Lee Marsh added to contest of election for aiding defendants in acts of RICO and treason. So you bring up RICO here, but this is the only place that I've seen it so far. Is this something you're going to pursue in the future, or you have a parallel filing that possibly will be filed soon, or an alternative group working on that? What's that look like? And I'm waiting for her to type her answer. If you guys on YouTube land, if y'all have any questions for Christine or myself, put them in the chat. I'll get over there in a minute. Oh yeah, he's not even letting your chats go through now. He's just being mean. I mean, come on, man. Really? Oh, here we go. RICO is in both of my Leon cases for 2020 and 2022. So did you cite the federal RICO statutes or Florida RICO statutes? And in Florida, are their RICO statutes adopted in whole from the federal RICO statutes, or in part, or did they have their own? Because what some of you may not understand, RICO is a very powerful tool. It got overused back in the 80s, 90s, early 2000s, to the point where it was pretty much abandoned by all courts because of its overuse. But it is of my opinion that it definitely needs to come back, and it needs to have some very serious criminal penalties attached to the end of it, liability and responsibility. Both Florida and the federal statutes as well as their own. Okay, so it's similar to Georgia, because Georgia and New York both have adopted the federal statutes in whole, and of course they've twisted them to fit their own needs for their own jurisdiction. Okay, so I got through that. Did you want to address what we were talking about before we kind of got disconnected?
Yeah.
Okay. I heard, yeah. Got that out. Thanks, bro.
I Okay, well, I'll try to talk, but you can hear me. Can you see me?
I can see you. Yes, I can. Uh, I don't think anybody else can.
They can.
I don't think so. That's what's nuts. Here, let me go back to the YouTube. Oh, there you are. Okay, yeah, they can see you. They can see you when you talk. Yeah, when you're quiet, they see is me. So
Oh,
you have to talk, even if you're typing.
okay.
Yeah, talk. There you go. Yeah. So talk and if I can't understand anything, I'll just get you to rephrase it. So hopefully he has
Yes.
some more Morse. All right. I have no questions over
I'm
the.
happy to say about I'm happy to talk about the um, prayer and the conclusion. They're actually the same. You can use either word
Mhm.
and pray to the court. So I use the word. Um, it's just a choice. So my prayer is within. It's the same thing as a conclusion. So my demands, what I'm asking for, have been
Okay.
put
How
in the conclusion.
how I was trained regarding that particular issue um, is when you send a vehicle in, legal vehicle, this one being you're the mandamus, I'm not in front of it anymore. Right here. And I have the title highlighted, which you can't see because the virtual background. But anyway, the title of this is Application to Associate Justice Seeking Review of Petition for Writ of Certiorari under Supreme Court Rule 1112 FRAP 2 and 11th Circuit Local Rule 2-1. Uh, but basically, how I was trained is read the title and then you go to the prayer to see what kind of relief they want. This is what they're asking for. This is the relief. Now, I was explained that when you use the term conclusion, that's closing the case, that you've concluded it. I'm done. You've thrown your hands up. I'm done in your statement. That's why you should keep it as a prayer for relief because you're describing what it is. What I was told is that some of the clerks, they'll go read the title and then they'll go read the prayer. And if there's no prayer, it goes in the garbage. That's what they look for. So that would be the only critique that I would have over this. I'm extremely impressed with what you've done. I will even volunteer my services next time that you do put together something like this. And I get it because you reread it and reread it and reread it. You miss typos, even though you might do a spell check and grammar check and all that, they still get missed. Uh, Run it by me. I'll edit it,
Okay.
send you a copy. I've been there. You're just all you can see is words.
All right. So, okay. Okay. I only had 2 weeks to do this, and it wasn't very long. And so I didn't have time to write down to the wire on it. I did not have time to even proofread. So there are problems. There are side effects. And it was a time issue. It wasn't that I used spell check. It was that after that, within the first case, I had about 4 minutes left. Can you hear me?
Yes, it's cuts in and out, but yeah, I got the gist of it.
Okay, so as far as prayer versus conclusion, okay,
Uh-huh.
um, I am not a lawyer. I don't know anything about law. And so the only things that I learned about it, I learned from law books or procedure books. And I read that uh, um, oftentimes instead of calling it a prayer, it is called a conclusion. And so I have no obligation to call it a prayer. And most often, I don't see it as a prayer in other people. So usually everyone on the other side of a case is a lawyer and a well-seasoned lawyer. And they usually put the prayer in a conclusion. Here, from what I've seen down in Florida, Leon and down here in Florida. So from my experience, the conclusion is accurate, and they may not throw it out based on that. Further, I'm pro se, and as a pro se, that would be a procedural matter, and they have to consider that liberally. They wouldn't be able to throw it out under those circumstances.
Okay. Have you ever read any of my work?
No.
Okay. This is what
you,
I
you're
filed.
new to me.
This is what I filed into the Brunson case.
Okay.
And of course, I have my estate gold foil embossed seal up here to go with this document. Gave it some equity. You see who all it's addressed to? All the justices, the clerk, the marshal of the court, reporter of decisions, court counsel, curator, everybody associated with the Supreme Court of the United States. This is the reference. This is a friend of the court, equitable acknowledgement, affirmation, and acceptance of oaths of office in and for the United States Supreme Court, Chief and Associate Justice, including but not limited to court officers concerning criminal acts of treason and treason-related offenses, conflicts of interest, witness statements, and prayers for relief, which may be granted as a stated claim, signed, sealed, and delivered. And of course, you see I have my copyright notice here at the bottom. And I'll show you some other little neat tricks I did. This is judicial notice. I've already read what it states. To all men, know by these presents, greeting. I, Floyd Pleasant Harvin IV, hereafter, American, a man of substance and as an inhabitant of the land, United States of America, breathing air and from water, hereinafter law, so graciously provided to all by the creator of all, and here being created in God's image, I come as a peaceful, non-combatant, law-abiding American, and hope this letter finds you well, in honor, good faith, and with clean hands. Oaths of office. We will know by this that we are of the truth and will assure our heart before him in whatever our heart condemns us. For God is greater than our heart and knows all things. Article 6, Oath of Office. I, as an American, herewith judicially notice the Chief and Associate Justice and court officials thereto, that as a law-abiding American, your oaths of office pursuant to Article 6, U.S. Constitution, see and set below, are equitably, lawfully, and legally for valuable consideration receipt upon which is hereby acknowledged, in which I hereby remise, release, and grant to all law-abiding Americans all relief, remedy, and orders insomuch as prayer in all things, this honorable court grant rehearing to petitioner Brunson versus Adams et al. 22-380, hereinafter Brunson, or in whole. I, Justice Clarence Thomas, do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, and I will bear true faith and allegiance to the same, and that I will take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. Judicial oath of office. I, as an American, herewith judicially notice the Chief and Associate Justice of the court officials thereto, that as a law-abiding American, your oaths of office pursuant to your judicial oath pursuant to Judiciary Act of 1789 and Judicial Improvement Act of 1990, see inset below, are equitably, lawfully, and legally for valuable consideration, receipt of which is hereby acknowledged, and which I hereby remise, release, and grant to all law-abiding Americans all relief, remedy, and orders, insomuch as we pray in all things this honorable court grant rehearing to petitioner in Brunson for relief in whole. This is their oath. I, Justice Clarence Thomas, do solemnly swear or affirm that I will administer justice without respect to persons and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as the Associate Justice of the Supreme Court under the Constitution and laws of the United States. So help me God. And this is where I hit him with another prayer. I solemnly charge you in the presence of God and of Christ Jesus and of his chosen angels to maintain these principles without bias, doing nothing in spirit of partiality. Judicial canons of law. Canon 1, a judge shall uphold and promote the independence, integrity, and partiality of the judiciary, shall avoid impropriety and the appearance of impropriety. Canon 2, a judge shall perform the duties of judicial office impartially, competently, and diligently. Canon 3, a judge shall conduct the judge's personal and extrajudicial affairs to minimize the risk of conflict with the obligations of judicial office. Canon 4, a judge or candidate or judicial office shall not engage in political or campaign activity that is inconsistent with the independence, integrity, or impartiality of the judiciary. Conflicts of interest. Attorney-client relationship requires an attorney's first duty is to the courts and to the public, not to the client. And wherever the duties to his client conflict with those that he owes as an officer of the court and the administrative justice, the former must yield to the latter. See 7 Corpus Juris Secundum, Section 4. Therein belies a client who is one who applies to a lawyer or counselor for advice and direction in a question of law, or commences cause to his management and prosecuting a claim or defending against a suit in court of justice. One who retains the attorney is responsible for the management of the suit, and who communicates facts to an attorney expecting professional advice. Clients are also called wards of the court in regards to their relationship with their attorney. See 7 Corpus Juris Secundum, Section 2. So anybody who retains an attorney and goes to court are wards of the court. They're imbeciles. Herein, clearly and unequivocally, respondents have commenced cause to his management in prosecuting a claim or defending against a suit in a court of justice as one who retained the attorney and responsible for the management of the suit, one who communicates facts to an attorney expecting professional advice. Respondents are also called wards of the court in regard to their relationship with their attorney, in which herein lays a fundamental flaw of constitutional magnitude that all justices, and more likely than not, court officials named and unnamed herewith, have sworn, affirmed an oath to a state and or federal bar, as well as 2 oaths or combined oath pursuant to Article 6 U.S. Constitution, Judiciary Act of 1789, Judicial Improvement Act of 1990. B, bar oath of allegiance. As officers of the court, lawyers are sworn to support the Constitution, not just of the state in which they seek to practice, but above all to support the Constitution of the United States. This promise is included first in every state's attorney's oath and is the most important promise that a new attorney will make. It commands an attorney to take action to ensure the supreme law of the land is followed and upheld. This promise is a burden on all lawyers. Every lawyer must defend the U.S. Constitution in all ways at all times. See The Anatomy of Our Oath by Robert Gottfried. Quote, no one can serve 2 masters. Either you will hate the one and love the other, or you will be devoted to the one and despise the other. You cannot serve both God and money. Be careful not to practice your righteousness in front of others to be seen by them. If you do, you will have no reward from your Father in heaven. Acts of treason. Title 18 U.S. Codes. Treason, sedition, and subversive activities are running rampant throughout the halls of Congress, all the way to the White House, without judicial intervention to remedy clear and unequivocal treasonous acts, misprision of treason acts, rebellion or insurrectional acts, seditious conspiracy and or advocating overthrow of government, failing to defend the Constitution of the United States against all enemies, foreign and domestic. See Constitution Amendment 6. Treason. Further, whoever owing allegiance to the United States levies war against them or adheres to the enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death, or shall be imprisoned not less than 5 years and fined under this title, but not less than $10,000, and shall be incapable of holding any office under the United States. B. Misprision of treason. Whoever, owing allegiance to the United States and having knowledge of the commission of any treason against them, conceals and does not, as soon as may be, disclose and make known the same to the president or some judge of the United States, or to the governor or to some judge or justice of a particular state, is guilty of misprision of treason and shall be fined under this title or imprisoned not more than 7 years or both. See Title 18, Section 2382. Rebellion or insurrection. Whoever incites, set foot, assists, or engages in any rebellion or insurrection against the authority of the United States or laws thereof, or gives aid or comfort thereto, shall be fined under this title, in prison not more than 10 years or both, and shall be incapable of holding any office under the United States. Title 18 U.S.C. 2383. Seditious conspiracy. If two or more persons in any state or territory or any place subject to the jurisdiction of the United States conspire to overthrow, put down, or destroy by force the government of the United States, or to levy war against them, or to oppose by force the authority thereof, or by force to prevent, hinder, or delay the execution of any law of the United States, or by force to seize, take, or possess any property of the United States contrary to the authority thereof, they shall each be fined under this title or imprisoned not more than 20 years or both. Advocating overthrow of government. Whoever knowingly or willfully advocates, abets, advises, or teaches the duty, necessity, desirability, or propriety of overthrowing or destroying the government of the United States, or the government of any state, territory, district, or possession thereof, or the government of any political subdivision therein, by force or violent, or by the assassination of any officer of any such government, or whoever, with the intent to cause the overthrow or destruction of any such government, prints, publishes, edits, issues, circulates, sells, distributes, or publicly displays any written or printed matter advocating, advising, or teaching the duty, necessity, desirability, or propriety of overthrowing or destroying any government in the United States by force or violence, or attempts to do so, or whoever organizes or helps or attempts to organize any society, group, or assembly of persons who teach, advocate, or encourage the overthrow or destruction of any such government by force or violence, or becomes or is a member of or affiliates with any such society, group, or assembly of such persons, knowing the purposes thereof, shall be fined under this title or imprisoned not more than 20 years or both, and shall be ineligible for employment by the United States or any department or agency thereof for the 5 years next following his or her conviction. If two or more persons conspire to commit any offense named in this section, each shall be fined under this title or imprisoned not more than 20 years or both, and shall be ineligible for employment by the United States or any department or agency thereof for 5 years next following his or her conviction. As used in this section, terms organizes and organize with respect to any society, group, or assembly of persons include the recruiting of new members, the forming of new units, and the regrouping or expansion of existing clubs, classes, and other units of such society, group, or assembly of persons. Again, 28, Section 2385. Testimony of two witnesses need to prove treason. Basically, is what it is. Congressional mandate. Contested elections for federal office are governed by the federal law, specifically the Federal Contested Elections Act and the Federal Election Campaign Act. The FCEA, they love their acronyms, provides a framework for resolving disputes over the election of members of the House of Representatives. The Federal Contested Elections Act, under FCEA, the candidate who loses an election can file a contest with the clerk of the House in 30 days after the election. The contest must be held in writing and must allege that the winning candidate is not qualified to hold office whether the election is tainted by fraud, corruption, or other illegal contact. Where have we heard that before? If the contest meets certain procedural requirements, the clerk of the House must notify the challenge candidate, who then has an opportunity to respond. The House Committee on Administration is then responsible for investigating the contest, making a recommendation to the full House of Representatives. If the full House determines that the election is valid, it will declare the seat vacant in order for the election to be held. If the full House determines that the election was valid, the winning candidate is seated. This American and witnesses here do clearly and unequivocally state herein on the record, under penalty of perjury, that treasonous acts have been perpetrated by all actors as statement of claim by Brunson, including but not limited to POTUS, Joseph R. Biden, Vice POTUS, Kamala Harris, former Vice POTUS, Mike Pence, and 385 members of U.S. Congress for violating their oaths of office by voting nay for the proposition submitted by members of Congress to investigate the claims that were enemies of the Constitution who successfully rigged the election, and declare under perjury under the laws of the United States of America that the foregoing is true and correct, executed without the United States on the 25th day of February 2023, Texas Civil Practice Remedies Code sections 132.001 et sequetra. Witnesses to my treason or to their treasonous acts right there. And the final prayer: Our Father in heaven, hallowed be your name. Your kingdom come, your will be done on earth as it is in heaven. Give us today our daily bread, and forgive us our debts as we also have forgiven our debtors. And lead us not into temptation, but deliver us from the evil one. Wherefore, premises considered and all presumptions rebutted, oaths of office is acknowledged, affirmed, accepted of, in, and for the United States Supreme Court Chief and Associate Justice, including but not limited to court officers concerning conflicts of interest, criminal acts of treason, and treason-related offense. This American judicially notices all the above described persons that America is watching under God with liberty and justice for all. Not only are your reputations at stake in this matter, but your very own lives are now under the microscope of all Americans, as we will know truths self-evident by your actions, whether the Supreme Court of the United States is compromised for treasonous actors corrupting America from the inside out. In all things, this American so prays, this most honorable and distinguishable court uphold all dignity, courage, integrity, ethics, morals, and standards of all Americans, and hold accountable those actors who have clearly and unequivocally failed to honor their oaths of office, and expel those actors from the political arena and introduce them to the criminal justice arena so that the American people can instill the full faith and credit of the United States branches of government. And this court issued an opinion in favor or all relief so demanded by Brunson. So be it, so be it, so be it. Amen. There's my certificate of service. And there you go. My little 8-pager.
Wow. Yes.
You like that?
Wow. Yeah, it's so are you a lawyer?
Am I what? You're going to have to type that question. Can you do that? I can't hear a word you're saying. Nothing. Not a word. Wow. Guys hacking us like this. This is crazy. Let me go over here, see what we all have. Yes, her voice is very choppy. She's being hacked, and you guys are seeing a hack job in real time. She's actually being hacked. she's actually watching him hack her on her phone. It's strange, very strange what's going on. All right, no questions over there. Get back to Christine. Am I a lawyer or pro se? I am a self-educated, self-taught pro per litigant, published multiple times, have been in every state or county, state, and federal court between Houston, Texas, and Washington, D.C. All at the same time, actually. County criminal court at law, district court, two courts of appeals, Court of Criminal Appeals, Texas Supreme Court, U.S. District Court in Houston, Fifth Circuit, U.S. Court of Appeals, and U.S. Supreme Court. Yeah, all at one time. I used to be like mad crazy with law. That's all I did. No. Oh no. They kicked it straight back. Yeah. Here it is. Right here. See the my Gulf War symbol up there. Uh, but I put a little post-it on here that says King's copy, please file, mark, and return to, because it says Floyd Pleasant Fourth King, Kingdom of the Tarvin State. And that's how I addressed it and sent it to the U.S. Supreme Court and called it my letter of wishes. National and employer demand for execution of law and rules of procedure, execution of contracts recognizing political property rights and American people administrated by public servants. And I believe this one was the, oh yeah. Yeah, this one's even a different one. This one I think is for the rehearing. I did another one, the second filing. Uh, but yeah, this is my reply from the Scott Harris, one of his representatives, and they called me Floyd King, which I found funny. Dear Mr. King, first, uh, the reference is special divine appearance. Dear Mr. King, in reply to your letter or submission received January 5th, 2023, I regret to inform you that the court is unable to assist you in the matter you present. Under Article 3 of the Constitution, the jurisdiction of this court extends only to the consideration of cases of or a controversy properly brought before the court or properly brought before it from lower courts in accordance with federal law and filed pursuant to the rules of the court. Your papers are herewith returned. So they're in reference to the Brunson case. So yeah, that's how they act. And I can tell that you may have experienced this. If you do a mail-in hard physical copy, you're going to get your papers back, but they're going to have like a beige tint to them, a tan tint, because they run all the papers through a chemical. And that's how they know that your paperwork has been processed by the United States Supreme Court. Absolutely. I have filed instruments into the United States Supreme Court on toilet paper wrappers that were carbon copy. Yeah, they wouldn't give me paper in prison. All right, I'll send it to the Supreme Court like this. I ain't tripping. Yeah, I used to have them. Yeah. Oh, yeah. Yeah. And let me ask you this. Let me see. Did the Supreme Court accept your filing Brunson case? No. I filed an amicus brief, which they also did not accept. They don't accept input from pro se's. They don't like people who aren't licensed bar attorneys who are smarter than they are. That's what they don't like. It's not so much your pro se, it's just you know a little too much. And they don't want you running around in their courts recklessly because they can't control you. They don't know what's going to come out of your mouth. That's why. I was in prison. Yes, I've been to prison 3 times in Texas. Just give you a little background on myself. Um, I picked these up at the motorcycle rally a couple of days ago, but basically it says, I am the person your parents warned you about. Literally. I'm serious about that. I used to be a lunatic. I had absolutely no boundaries. All I cared about was having fun and self satisfaction. Thank God I didn't have to hurt anybody to do that or steal to have that type of lifestyle. For somebody who spent almost 18 years of my adult life behind bars, I've had a very unique, um, awesome life. I'm not messed up once about going to prison. This last stint turned my life around. I can't tell you when, I can't tell you where, I can't tell you why. All I know is between January 1st, 2016 and April 15th, 2016, I was in Brownwood, Texas on the Havens unit doing the remaining 3 months of a 6-month in prison therapeutic treatment program. And something snapped in me and it said, you know what? You cannot go back out there and be the person you were. If you do, you're going to come back and you're going to do the 60-year sentence on layaway. And that's not how you want to live the last part of your life. And I got out and I was like, wow. And I have changed so much that I don't have any friends anymore because now they're around me and I'm like this dull guy. I'm the guy that drives drunk people home. Uh, I'm the boring guy. I used to be the most adventurous, craziest idiot that would, so unexpected things that I would do that because I am the fourth, we all have nicknames. My dad was Buddy. I'm Scotty. And when I got out in 2016, I'd run into people that I hadn't seen, of course, in a couple decades. And they go, oh, hey, do you remember when? And they would start telling me this just wild, bizarre, off the chain story. And I'm like looking at them going, and I'm thinking to myself, I have no idea what they're talking about. And then they'll finish the story and I go, are you talking about me? And they're like, yeah, you don't remember? And I'm like, I don't have a clue what you're talking about. That's the most insane story I think I've ever heard. And as I keep running into these people, they keep telling me these stories over and over. And it got to the point where we're like, how come I should be dead a couple times in these stories. They're that lunatic. I mean, it's bizarre. I'm terrified of that guy. I mean, that guy was just nuts. I mean, yeah, I was the guy your parents should warn you about. But something clicked in me. Uh, and I didn't jump on YouTube and create this channel. This channel was actually supposed to be about music because I love going to concerts. I'm actually a professional stagehand and rigger. I work in the theater, concerts, trade shows, political rallies. I do it all. Something happened to me, and I can only say it's a divine intervention, and I'm here for a reason. And God leads the way. That's the only thing I can say. And He puts people and things in my life that allow me to assist other people and help other people and be a true humanitarian. Because of all the skid marks that I have left in my past, it is my own future sacrifice to leave a better mark on humanity any way I can. to redeem myself. So that's my daily goal, is to help at least one person a day to get, man, thanks, Floyd. You really helped me out with that. If I can get that, I've done my job. So that's what I try to do, is educate many people as I can with the truth. I try to get to the facts. I don't speculate. So you get what you see is what you get. And I'm not going to blow smoke up anybody's ass just to make them feel good, and so they can blow out glitter and unicorns and rainbows. That's not me. I dig for the truth. That's why I think that what you have accomplished so far is enormous, and why you're not on Fox News and all these other independent media talking heads, Right Side Broadcasting, Michael Jaco, Scott McKay, all those people, is beyond me. I don't, why they're promoting the Brunson brothers against what you've done. And matter of fact, let me show you guys something, because I went and pulled it up. So I want to show you the difference. Oops, sorry. So, way. All right. And stop share, go back share, just to make sure that it is sharing, because Zoom will do that. Here we go. This is one of the Brunson's filings. Okay. And this is a petition for writ of certiorari out of the 10th Circuit, which is Utah. And this is Raylan Brunson, who I have personally spoke to on the phone, volunteered my services along with Brian Robinson, pastors away, and we were rebuffed. So this is his filing. This is his writ of certiorari. These are his questions presented, and this is in proper Supreme Court rules formatting. Parties to the proceeding. And it has more parties to the proceeding than actually meat and potatoes in the actual brief, because we're still trying to get to it. He's just giving you the provisions, statement of the case. And basically, I've read all this already. But you see, there's no legal sightings, no Supreme Court precedent, nothing. Very minimal. Here they are. This is a Texas case. This is a Kentucky case. Okay. Those cases hold zero authority in Utah. Zero. None. And this is a big problem with people self-litigating, is they use statutes from other jurisdictions that have absolutely no bearing on the jurisdiction they're in, and they're trying to find relief. Zero. And I don't know why people do it and constantly do it and teach other people this way of doing it, which is 100% incorrect. This is, and I'll address this, and when I say this, completely, you'll understand it. There's a thing called split circuits. Okay. We'll have the Fifth Circuit, they're conservative court. They're going to rule one way on abortion or gun laws. Then we're going to go out to the Ninth Circuit out in California. They're liberal. We know how they're going to lean. They're trying to take gun rights, and they want abortion. Okay. Now, they both make a ruling on gun rights and abortion. We have a split circuit because the Fifth Circuit's ruling this way, the Ninth Circuit's ruling that way. So it has to be decided if it comes up in another circuit, like the first, second, third, DC circuit, wherever, that it has to go to the Supreme Court. The Supreme Court has to determine the split circuit. Okay. So nothing holds up because it's a split circuit. It has to be ruled on by a higher court. It's the same thing what we're talking about on this lower level, if you can comprehend that. Do you have any question? Oh, why was I in prison? That's a good question. In 1981, I just graduated from high school. While I was a senior in high school, I was a raging alcoholic. a junkie. I was freebasing cocaine, uh, dropping acid, eating mushrooms, just pretty much abusing myself and just I don't even know why. Uh, but I didn't even know what freebasing cocaine was. And the only reason I even really knew it was called freebasing was because Richard Pryor managed to catch himself on fire freebasing cocaine. I was like, oh, that's what I'm doing. Okay, I'm just over here getting high. So I went to, I accidentally ran over somebody, killed him. So I have an involuntary manslaughter charge. While I was out on bond on that, again, I was totally intoxicated, blacked out, and robbed the wine gardens with two other co-defendants. Then in 85, I sold a quarter pound of cocaine to undercover narcotics officer with Houston Police Department, Bob Romano, who I have recently rekindled an association with, believe it or not. Yeah, yeah, I don't hold any grudges. It is what it is. And then again in 2001, I picked up my third DWI, which was basically speeding down Westheimer. They made it a DWI. The DWI statutes in Texas state that if you have two prior misdemeanor and or felony DWIs, it can be used as a element of defense to enhance the misdemeanor DWI to a third degree felony. Then they use two prior felonies to enhance me as a habitual felony offender under Texas Code of Criminal Procedure Article 1242D. And I was facing 25 to 99 or life, and took it to trial and lost and was sentenced to 60 years, did 14 years, 2 months flat. Released April 15th, 2016, and have remained out on parole the entire time. That's my story in a nutshell. And I've done a whole bunch of crazy stuff in between. So I'm very experienced in the court system, prison system. I consider myself an expert on the Texas prison system, as well as the Texas judicial system. I've experienced the corruption over and over and over and over as such yourself. Once you experience the corruption and you get screwed over through the corruption, it changes your entire life, your whole outlook on everything. It's very, very strange. Um, but like I said, I have no regrets on how I lived my life. There's a couple of decisions, I wish I could have changed, that were probably vectored my life in a different direction, but it didn't. And I am where I am. I am who I am, and I am what I am because of who I am. I'm very upfront, transparent, open about everything I do. Everything that I've done is obviously clearly a public record. My phone number is out there. My social security number is out there. My certificate of live birth number is out there. All my numbers are out there. It's all you gotta do is go watch my videos, and you'll have all my information. I'm not trying to hide anything. Never have, never will. I'm not going to give anybody that advantage over me to hold something I've done over my head. You know, I don't even remember doing it. So what good's gonna do holding it over my head? That's the crazy part. Yeah, I don't remember any of it. It's like I was in this just, I don't know, decade long blackout. It's real weird. We lost Christine again. So anyway, let me dive back into her writ while we're waiting on her hacker to release her from captivity, from cyber captivity. Let's see. And let me get it now. I got it. All right. So while we pulled her back up, let me go into her other instrument that I have pulled up. Um, yeah, there's the conclusion. So And basically, that's just a semantics issue. I kind of understand why it was addressed to me, but I'm going to say we, because me and several of my close associates, we like to use scripture as much as possible in our prayers because they can get away with it in this realm, but can they get away with it in the other realm? That's the question. Okay. So if you have any doubts, hey man, knock yourself out. Do what you got to do. Don't be mad at you. All right. I am looking for her other. There. Here it is. Jumped off of it. All right. So let me get over here. Yeah, she's still frozen. Send her a chat. She can read that. I'm going to close that out. Let me get over here and share the screen. All right. This is our latest filing. Derived from an emergency application addressed to the Honorable Supreme Court Associate Justice Thomas, who presides over the 11th Circuit of the United States Court of Appeals and brought forth under the Supreme Court of the United States Rules 1122, United States Court of Appeals Federal Rules of Appellate Procedure, Rule 2, and the United States Court of Appeals 11th Circuit Rules of Appellate Procedure, Rule 2-1, relating to an election interference meant to undermine the national economic security of the U.S. by way of an ongoing coup by foreign and domestic enemies of the state, of which is of imperative public importance. Petition for writ of mandamus. Parties to the proceeding. Okay. Basically, uh, without having to name all of them, basically all 50 states. There you go. Now, I'm not even going to name these people. These are the interested parties. And as you can see, she has a alphabetical list. A lot of these are Google, Facebook, election companies, FBI, Staple Street Capital, BlackRock, Center for Disease Control. I mean, this is a wide net, and it goes on and on. You see, she had started, a couple lists, adding people on. Putting an instrument, a 107-page legal instrument together is a daunting task. You pretty much have to lock yourself in a room, turn your phone off, not answer any emails or social media, and just focus on getting it done. It's very time consuming, tedious, and she's done a wonderful job. I'm very, very, very proud of her. I mean, she could easily be an attorney. This work, I will tell you, is better than a lot of court-appointed appellate attorneys' work that I have read. As you see, I'm still going through interested parties. YouTube, Rock the Vote, Center for Democracy and Technology, Democracy Fund. It just goes on and on and on. Alphabet Inc., Larry Fink, BlackRock. You know who that is. And we are like, 30, I think it's 33 pages, 31 pages of interested parties, pretty much, about 30 pages. Corporate disclosure statement, statement of related proceedings, table of contents. Now, I don't know if you guys ever put together a table of contents, but this is the last thing you do right here, your table of contents. And she's got it all lined up perfectly. Table of authorities, Federal case law. Boom. In alphabetical order, which is correct. United States constitutional provisions. United States codes in numerical order. We done. Florida constitutional provisions, same thing. Florida court case law. Okay. I don't know. This could have been broken down. I always break it down. Texas Supreme Court, Texas Court of Criminal Appeals, Court of Appeals. I break it down even further, just because of authoritative issues. But generally, I have way more sightings in this. I was a sighting beast. I'm still waiting on Christine to come back on. Hopefully, her hacker will grant her parole, clemency, or a furlough. Come on, bro. Give us a furlough. Give us 5 days in the free world. Florida statutes. And of course, in chronological order, numerical order, rather. Sorry. Rules. Other authorities. Now, right there, that's Louisiana. Okay. That's where that's coming from. These are other authorities. They can use them as a reference. Okay, well, what did Louisiana do in this circumstance? Oh, that's what they did. This is how their courts ruled. We'll take that under advisement, just like that. Or we're just going to dismiss it in whole or in part. All right. Criminal Code Section 20. I don't know what criminal code that is, what jurisdiction. China's 2005 War Doctrine, Executive Order 13848. And she put this in numerical and correct alphabetical order. Statement of the case, jurisdiction. Excuse me. Standing, relevant constitutional and statutory provisions involved, relief sought, issues presented, facts necessary to understand the issue presented by the petitioner. Reasons for granting the petition. Petitioner's right to issuance of writ is clear. Writ of mandamus is warranted given the urgent circumstances of the case. No other adequate means to obtain relief exists. And the conclusion at 105. So let's get through the table of contents, index of authorities, and statement of the case. The petition stems from an application to Circuit Justice Thomas, filed in this court on October 17th, 2023, in response to a notice of counsel to fix deficiencies filed on October 23rd, 2023. The emergency application was filed addressing an active coup by foreign and domestic enemies who have infiltrated every branch of government at every level, federally and in every state in the Union, in part by way of altering, manipulating, and concealing real vote counts in every candidate and referendum race at every level throughout the entire country due to illegal use of vulnerable and compromised election equipment that has proven to be an act of war with an equally devastating impact on the American people, as well as our national and economic security, as would be a kinetic attack or an EMP or even nuclear or conventional weapons, even biological, chemical. Should I go on? And who's taking money from China? Allegedly, Joe Biden. All the way to the top, folks. That's why I try to hold the Supreme Court accountable. Are you going to commit treason, or are you going to get down with we the people? You going to be one of the we the people, or are you going to be against we the people? You're going to war upon us. Because if you're going to war upon us, you're committing treason, and we need to execute you. Just saying. Due to the rampant violations of Scott's constitutional right to a fair and honest election, which by default creates the same injury for every other American, she brings this urgent matter to this court for immediate resolution based on the imperative public importance to ensure the sanctity of election process. Jurisdiction, which is correct. Standing, of course, she has standing. She's a voter. She was in the actual election per se. Scott alleges there is a credible threat to her freedom, liberty, pursuit of happiness, and other civil rights by foreign and domestic enemies attempting to overthrow the government of the United States of America, Florida, any other state of the Union, which individually and cumulatively threaten the sovereignty of the state and country within which Scott resides and within which her rights are protected. For the reasons listed above and throughout this petition, Scott has standing under Article 3, Section 2, Clause 1, because she has a genuine stake in the outcome of the case and has been and has suffered and will imminently suffer in her country within which her constitutional rights exist were to fall to enemy forces in a strategic unconventional attack by way of election fraud, which is currently an imminent threat with a high likelihood of occurrence if Scott's petition is not granted. A favorable judicial decision would protect Scott's right to an honest and fair election at a state and federal level. This basically supports her arguments. Scott has a right to access to the courts. Absolutely. Meaningful access to the courts. Courts shall be open 24/7, 365 to all people. She cannot afford to file this in the Supreme Court due to the paper copy requirement. For this reason, she opted to file it to Justice Thomas per 11th Circuit of the United States Court of Appeals because Justice Thomas presides over the circuit. They require non-custodial individuals or persons, rather, to file under the Supreme Court formatting, which it's a little book. If you've ever ordered the rules, well, it's about this size. It's a little bit smaller than this. A little smaller than this little magazine or catalog. It's hard to see. There we go. This is a little coupon for apparel. But it's about this size. There's, I want to say 6 inches by 8 inches or 6.5 by 8.5, maybe something like that. Real odd size, real odd formatting, but that's how they like it. They like it in the book form. And then, of course, the book has to be sent to everybody. So production costs just to litigate in the United States Supreme Court is costly because you have to have that proper format. Like I showed you with the Brunson's case. Absolutely. So she opted out, took it that way, which I don't blame her. As I said, I've filed on, toilet paper wrappers, literally. Relevant constitutional statutory provisions involved. We've covered all this. Relief sought. We've gone through this, but let's go over it. She has, 5 issues here. Number 1, declare nullification of the 2020 and 2022 elections due to foreign interference with U.S. elections, as well as rampant misconduct, fraud, and corruption in every state, both enemies of the state, both foreign and domestic. Number 2, declare the military is in control until a new election had be held or can be held. Number 3, order a new election to be held on November 5th, 2024 for all elected positions in all states at all levels of government. Now, because I see a typo and I bring it up, this is no fault of Christine's because believe me, my filings had a gazillion typos in them. And, when you're putting together a 107-page document or a 100-page document, you've got to remember what you did on page 20 at page 80. Especially when you get to table of contents, you've got to go back and reread the entire document, put the table of contents together. Absolutely. So you've read this document probably 100 times, and it's just a blur. That's all it is. It's just a bunch of words blur. You're trying to keep everything in track in your head, and sometimes it gets daunting, and you get lost, and you can't get in there and correct all the little minute errors. And yeah. So they make it through sometimes. No big deal. No criticism. It's a thing, especially when you're under a deadline and you have 24 hours to crank out a 50-page motion. It's got to be in the mailbox when they come pick up the mail. Otherwise, it's not going out that day. It's not going to be postmarked before your timeline occurs under the rules. Number four, Scott seeks damages based on violations listed throughout these petitions of $17 trillion from the parties who interfered with the 2020 and 2022 elections. Number five, order the new election be manual without the use of electronics, one-day voting, watermarked paper ballots, no device voting, military votes possibly transferred by hand by a member of our armed forces to protect the integrity of their vote, votes counted after polls are closed at the precinct until all ballots have been hand counted without stopping, then totals transferred to the supervisor of elections. Hand counted does not include the use of devices. No ADA machines are to be used. Tabulation machines are not manually counted ballots, nor is ticker tape totals. Reopen small precincts. No supercenters. Photo ID, proof of citizenship, and voter registration. Well, it's not too much to ask, I don't think. I mean, what do you have to drive on the streets? And obviously, when these, umpteen million illegal immigrants come through the southern border every day and then line up around the Texas Department of Public Safety driver's license offices. I mean, wrapped around the building every morning, going in there and getting driver's licenses and state IDs. Yeah. Issues presented. We've already talked about this. Vulnerable election equipment. She breaks it down, goes into detail. Actually has legal sightings. What are these? United States Supreme Court sightings. This is why I'm telling you, this compared to the Brunson brothers, it's even further apart than night and day, black and white. It's uh, like a real dump truck versus a Tonka toy dump truck. There you go. And again, all Supreme Court case law. Here's one, South Second. This is probably a Florida case. Second series. Okay, Florida. That's out of the Florida. That's the Florida Supreme Court. And certiorari was denied. And there's the citing where it was denied and when. And here's another Florida case. So you see, she's in Florida. She's citing Florida cases or United States Supreme Court case law, which is the what? Law of the land. Absolutely. Very well written. That's why I said, man, this woman has done a remarkable job all on her own. Christine, man, I got to give it to you. You've done an excellent job. Very, very, very good work. Thank you. Nobody else has thanked you. I'm thanking you. You have a open, public, generous thank you very much from Fearless Floyd. Yes, absolutely. And this goes into more. I mean, this is very lengthy. You guys can go pull all this up if you want. Go get you a subscription to Pacer. And as you see, she's citing, nothing but United States Code, U.S. Supreme Court case law. Here's that Louisiana case that I brought up that is from other jurisdictions. So let's read how this applies, how she applied it. Governor DeSantis, Secretary of State Cord Byrd, and Director of Elections for the Division of Elections knew and promoted the use of privately funded Zuckerbucks to be used in 11 counties in the 2022 and 2020 election cycles in violation of 1940 Louisiana Acts 46 and Section 35. The primary is conducted by the state at public expense, 1940 Louisiana Acts 46, Section 35. The primary, as in the general election, is subject to numerous statutory regulations as to the time, place, and manner of conducting the election, including provisions to ensure that the ballots cast at the primary are correctly counted and the results of the count correctly recorded and certified to the Secretary of State, whose duty it is to place the names of the successful candidates of each party on the official ballot. The Secretary of State is prohibited from placing on the official ballot the name of any person as a candidate for any political party not nominated in accordance with the provisions of the 1940 LA Acts, Louisiana Acts 46, Section 1. United States versus Classic 313 U.S. 299. That's the United States Supreme Court case. Absolutely. That's where she's getting the citing from. It's being cited by the United States Supreme Court. That's why she can use it. She has to cite it because here it is being cited. So that's how you use another jurisdiction's case being cited by us, the highest court in the land, allegedly. And of course, Christine looks to be gone. Her hacker has put her in prison. He's not letting her back in. No parole, no bond, no probation. So anyway, this goes on and on. I'm not going to go through all 135 pages of it, but we've gone through the gist of it. I really, 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 really wish she was able to speak to you guys. I've worked trying to get this interview for about 2 weeks. We've been rescheduling. She doesn't own a phone. The reason she doesn't own a phone is because, as you see right now, she's hacked. Even though she held up a phone, she doesn't use it. So I don't know. I've done the best I can with what I have available. I do apologize for the technical difficulties, but it wasn't my fault. It wasn't Christine's fault. We obviously see who the hacker is. In fact, let me get homeboy up here again. Get him live for you guys. There we go. This is her hacker. Right here, this guy. Now you see he's on the phone hacking. He actually waved to us, looked up and waved to us. It's in the video. You go back and see it. Even though this video is live, I am recording it and I will re-upload it. So you will have the full video. I know some of you guys jumped on here at in the middle. Oh, let's see. What do y'all have over here? I haven't been over here in a minute. Yeah, the reason her voice is choppy is because she was being hacked. Hey, Iran Lopez, haven't seen you in a minute. Why Zoom junk? You can find me something that's just as good. I'll use it. A mill to sell LLC. If we can hear her type, YC. Yeah, he was even preventing her ability to type. Yeah, I know it was horrible. Imagine how I felt waiting. Chet, drug addictions come from the diet of all processed food, leaves your body open, addiction, sugar, gluten, yeah. Uh-huh. Yep, I agree with that, Chet. Convicts constantly walk up to Judge Joe Brown, thanking him for the conviction, the programs he personally followed up on, helped him become a better man. Yeah. Hey, look, I would probably still be in prison if Rick Perry didn't have this huge ego, believing he could be the next president of the United States. And when he left office, Greg Abbott, who was the Attorney General, who had already battled multiple times, even beat me on a disability case. You know, somebody in a wheelchair fighting a disability case. Yeah, I know it doesn't make any sense, but uh, when he became governor, he brought the chair of the Board of Pardons and Paroles in there, Rizzy Owens, sat her down and gave her an ultimatum. Um, because people who had nonviolent offenses were doing like 90% of their time flat, were not getting parole. They were paroling all the sex offenders. Um, he told her, look, you got to change that up. You got to put these people in programs, get them the hell out of the prison system. It's overcrowded. And she refused to do it. He said, well, you can either turn in your termination, your resignation, or I will terminate you next week. And she turned in her resignation. He redid the whole system. I went through the treatment program. Trust me, I fought it the entire way. That's a whole nother story. Somehow it worked. Something worked. Can't tell you what, but something did. Can you chip in, mail a copy to Mike Lindell? I've reached out to Mike Lindell. I've reached out to Right Side Broadcasting. So I've tried. Um, yeah, I've reached out. This was a very important interview for me. I'm looking to step up my game and do some better interviews with better people. I'm trying to get away from the whole private side of everything. Not in whole. I would still cover it, but there's bigger, better problems out there that need to be solved, need to be brought to light, and I'm going to try to address as many of those as I can to better this country because this country's a freaking shithole. Sorry. I had to talk so bad about Austin, Texas today. It was pathetic because it is what it is. It's a cesspool. I hope you guys caught my movie night last night. We watched The Fall of Minneapolis about the whole corrupt, fraudulent George Floyd, Black Lives Matter, all that crap. If you didn't go watch it, I will upload it to Rumble, Odyssey, and some other platforms. I did it live. I immediately pulled it off YouTube last night because of that. All right. For those of you um, who are interested in taking a trust class, I have trust classes coming up. Mhm. Over here and show you. Oh, I should just went to the website. Let me just go to the website. That's silly of me to even contemplate not going there. All right. This is my website, fearlessfloydshow.com. If you want to email me here, just go right here, click on that. It'll open up the portal, send me the email. If you want access to the holiday deals, classes, books, merchandise, you just click this link right here. It's going to pop you over here to my store. If you're looking for books, consultations, holiday deals for this 2023 season, trust packages, classes, notary presentment protests, etc., this is where you need to go. Scroll up. Ann's books. Y'all look for these holiday specials, okay? Just because you see this, don't just click on this and buy it because right here for $259, you're going to get the ebook and the soft cover book combo, which is generally $359, $100 off for the holiday special. Right here is package two, is the soft cover and the ebook, 7 trusts. You also get every class we've ever done. VCR class, Trust 101, 201, 301, 401, and 501. All in there. You get access to all of that. That special is $699. So you get all the classes. You get the ebook and the soft cover book. Absolutely, $6.99. That's about $1,000 retail all day long. So knocking hundreds off that for you guys. If you just want the ebook, that's all you want. $149, $100 off. Get it. If you need remote online services, I also do that. I am a remote online notary. And as you see right here, here's a soft cover book. I told you it's $259, but boom, you come over here to the holiday special. It's a buck 40. Well, I'm sorry. It's $259, $100 off, and you get the ebook as a bonus. Isn't that cool? Now, if you this is a live one-on-one trust class. Let me explain this, guys, to you. I'm going to do a separate video on each of these packages to break them down for you, just so you understand exactly what this is. This is not the traditional 101 class for the revocable living trust that we have done in the past with Ann and myself. This is totally different. This is going to be roughly a 4 to 5 hour class. Why is it going to be so long? I'm going to tell you why. Because we are going to go through my own personal revocable living trust. We're going to walk through it page by page by page by page as you create your own revocable living trust in the background. For those of you who would like me to do your notarization of all your instruments, we will make arrangements and schedule you for the next day. I will schedule you in, and then we will do all your paperwork online. You'll have your 2 witnesses ready. We'll get you all completed the next day. I will, in class, walk you through getting your EIN. Okay. You cannot get your EIN until your trust is established. So your trust would be legally, lawfully established the next day because it would all be notarized, signed by your witnesses, and signed by yourself. Then you can get your EIN because the timelines need to correspond, that you did one before the other and didn't put the cart before the horse, which would invalidate both of them. So you have to do one before the other. And then your next step would be going and getting your non-interest bearing bank account for your revocable living trust after you have established the trust and created the EIN. And obviously, we're going to go over how to do the trust minutes. So we're going to walk through all that, create your trust, which is 24 instruments. You're not going to use all 24 because I'm sure you don't have direct deposit, Social Security, and a bunch of other things that the forms are there. They're available, but you may not even need them like I did. And I think I did 16 forms out of the 24. However, we can fill them out. But you'll be already good to go with your complete trust. You will get the free ebook, Ann's ebook, this one right here. You will get it free. It has revocable, irrevocable, foreign trust, land trust, express trust, college education trust. It's got a ton of 7 different trusts in there. So you're going to get the ebook. You're going to have everything you need to go create those other trusts. And you want to walk out of this class with a 90% completed trust process. That's what this is for. It is $400 because you're gonna have a trust done. You're gonna understand your trust. So after I go through the trust with you and we create it, we're gonna go back through the trust. We're gonna read it word for word, so you completely understand exactly what each document is, the authority of the power, and kind of understand how the trust is built and how it operates. Once we complete all that, then Ann LaFleur will come on for 1 hour and do a Q&A and answer any questions that you have regarding her process for the revocable living trust. My poochie's over here. She wants some attention. You need to go outside and go potty? I'm sure you do. Yeah, about that time. All right. So that's what I have available. I have these 4 packages. I'm also going to create some other packages, so be looking for them soon. Some people want the actual book and they just want the class. They don't want just the ebook. So I'm going to work it out and put some more packages together for you guys. Of course, I have the firm mailing books. I'm going to be running some blowouts on those. I'm waiting on my paper to arrive. As soon as it gets here, I'm going to start getting that cranking out, getting those together. Autograph books. I actually need to take this down because I don't have any autograph pages from Ann. I guess I could send her some, have her autograph them and incorporate them into the book. But the new books that will go out will have the new copyright from the Library of Congress incorporated in them. If you want a consultation with me, here you go. If you want a consultation with Ann LaFleur, here you go, right there. These are what we have offered as far as packages in the past. Package one, ebook and one-on-one class. This is $369. So you see the difference up here, right here. Same thing, for $30 more, you're actually going to have a trust created. And you're going to know how to do the EIN. I'm putting you guys so far ahead just by doing that. Uh yeah, you're going to be yeah, I'm going to save you a bunch of time and other things if you want to get all the one-on-one classes, et cetera, et cetera. And the $5.99 for every class does not include the 501 EIN foreign trust class. These prices were, as you see, you don't even see the 501 in here because it wasn't available at that time. I have to go remediate that, but that's something for me to do. It looks like Christine is not going to be able to jump back on. I'm kind of waiting for that to happen, and it hasn't. So um, we will do another video. I will continue to communicate with Christine. Hopefully, we can establish a better connection and get you guys something that you can actually, I hate to say pay attention to, but, you can hear her speak, which is a major difference in just hearing me speak and, you know, read you what she has filed. I'm sad that this happened this way, but it is what it is, and I'm dealing with it. So we're just going to move on. Thank you for being here. I really appreciate it. Each of you out there, have a very happy Thanksgiving if you celebrate Thanksgiving. Happy holidays. Happy American Heritage Indian Month or Indian Heritage Month, however you want to say it. Uh, Y'all have a safe, happy weekend. If you're traveling, be careful out there on the roads. I know it's treacherous up there in the northern area of the United States. So may peace be with you all. Christine, Scott, thank you so much from the bottom of my heart for coming on the show. I really do appreciate your effort, your patience. Uh, for the hacker, bro, come on, man, give me a break, man. Do I need to like slip you a C note under the table or something? I'm very generous. I will take care of people that need to be taken care of, especially my little puppy dog down here. She's just the best dog in the world. She's a good doggy. No, no. Give me 5 minutes and I'll be off. Okay. 5 minutes? Can I have 5 minutes? Can I get a high five on that? Give me a high five. Good girl. That's what I'm talking about. High fives from your pit bull. Like, subscribe, share this video, hit that notification bell so you know when I put out more videos. Please leave a comment below. If you want to reach me, the Fearless Floyd Show at yahoo.com. I am the Fearless Floyd Show almost on every social media platform you can think of or participate in. The Fearless Floyd Show at yahoo.com if you want to reach me. I'm mainly over playing in Telegram land. That's where I'm very familiar with that system. I'm able to move a lot of information because I am a subscriber at one time. So it's easy for me to transfer videos. That's why I like it. That's why I use it. Appreciate all you guys. If I don't see you before Christmas, happy holidays. Stay out of trouble. If you're on vacation, don't come back on probation. And as always, please